All right, AI is incredible at writing, but it's terrible at truth. And in law, truth is the whole job. I'm not anti-AI. In fact, I use AI every single day. I use it to build systems, automate my office, write content, streamline operations. But I refuse to use generative AI for client legal work. In the next few minutes, I'm going to show you exactly why. Because the danger isn't that AI makes typos. The danger is that it can sound 100% confident while quietly making up the law. Let's take a look at it. Over here, I've got a Llama open and ready to go. Right now, I have Gemma 3.1b. It's a very small model loaded. What I'm going to do is give a clause in this one. Gemma 3.1b is one that most of you can run. It's less than 1 gigabyte of space. It's 800 megabytes on your hard drive. So it could probably run in most of your CPUs if you have decent RAM available. I do have a video card, so this will run rapid fast. Here we go. Please draft the disinheritance clause for minor child that conforms to Missouri law and cite the statute. There's no way this puts out quality content. Here is a draft disinheritance clause tailored to Missouri law, aiming for clarity and legal compliance. I'm a chatbot, not a lawyer. That's true. Article blank, section 420, insert section number here, 420.1, disinheritance of a child, determination of legal capacity, make decisions be determined by a judge in following factors: parental consent. The rights of a parent disinheriting a child are forfeit upon the attainment of the child's majority. Loss of parental rights. This has nothing to do with what we asked. It sounds kind of good, although it did give us the citation for, well, frankly, marijuana. 421, I guess we're getting the good stuff. So I don't even know what 420 is. Let's go take a look. Trade and compliance section. You know what? I don't even have a chapter 420. That's between innkeepers and mattresses. So yeah, statute, pure crap. It also didn't even write the clause. So Gemma 3.1b is completely not solid for that. Let's take it up to a more competent model. How about Quen 2.5 14b, 14 billion parameter model? This model is usually capable for doing light writing and some minor editing. You can use it to make me an agenda or an outline for something. It's good for that. It's also good for picking out form fields. The Gemma one I just did, I used that model to verify form fields and make sure the dates conform to the date style I use in my database. Not anything complicated, and for that it is perfect. So popping this same clause into Quen 2.5 14b instruct. It is processing. This one takes a little bit longer to process. As you can see right here, need to comply with statutes. 474.10. While yes, 474 is the correct chapter, 0.10 is certainly not the correct statute. Okay, that is general rules of descent. Talks about property, who gets what. That's our basic intestate statute and how things are passed on. Okay, it doesn't cover disinheriting people. So one can disinherit a child through a will as long as proper formalities are filed. However, it's important to note that simply saying I leave nothing to my minor child or similar language may not be sufficient. Yeah, okay. Below is an example of how you might draft a disinheritance clause for a minor child. I, being of sound mind, blah, 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 blah. My express intention to leave nothing. Notwithstanding this, should they be entitled? The laws of the state, does my express desire such entitlements are waived. well, you can't waive something they're entitled to. They might be able to waive it, but you can't. So that's wrong. Testamentary capacity to make this statement, intend for a disinheritance clause to be legally binding upon my death. Citing a statute that doesn't apply. Strongly recommend to consult a Missouri attorney. Yeah, you should probably definitely do that. But if you are an attorney and you're using this, you can't use this. This is crap. It's not going to work. So let's go ahead and take it all the way up to the Gemma 327B. We'll pop that same thing in and see what that spits out. This is a much larger model. It's a 27 billion parameter model, and that means it barely fits on my system. I'm running a RTX 3090 video card, 24 gigabytes of visual RAM. This model is using 17 gigabytes, so I can load the whole thing into the GPU, which allows it to run pretty quick. Now, so here's a draft disinheritance clause. Note the important disclaimer at the end. Sample clause needs to be reviewed and tailored by a Missouri attorney. So, my express intent, make no provision for a minor child. I specifically and intentionally disinherit from receiving a share of my estate by intestacy, testamentary disposition, or otherwise. Made with full understanding of the laws of the state of Missouri regarding the rights of minor children, specifically 473040. Well, okay. So we're actually, yeah. We'll just leave that at yeah. That's not going to get the job done statute-wise. Now, if you're not an attorney, you probably wouldn't know that. That's administration of decedents' estates is the actual chapter. And that's actually a plus. We picked a chapter, but 473040 is notice when there are no known heirs. That is the publication requirements. When an intestate is left no known heirs, the clerk has to publish notice once a week for 6 consecutive weeks in at least 2 newspapers published in places designated by the court, containing the name of the intestate, a description of his person, time, place of his death, place of his nativity, if known, and the appraised amount of the estate. It has nothing to do with disinheriting anybody, but that sounds cool. It's written confidently. I acknowledge under Missouri law, a minor child may be entitled to a share of the estate, even if not specifically mentioned in this will, unless disinheritance is found to be clear, express, and made with full knowledge of the child's existence. There's no citation for that, and there's good reason. I further declare this disinheritance not based on a lack of affection, but on my considered judgment regarding best interest of my estate and well-being of the child's name. So, okay. Here are the problems. It's got this laid in here, and then it has statutory basis and explanation. It gives 473040 again. This is the key statute, and states in part that a child who is not provided for in will may be entitled to an intestate share. I just read you that statute. It does not say that at all. But just to make sure that you can see it, I'm going to drag this over into the screen. There we go. This is the statute in question, and it does not say that at all. Feel free to take a look. Actually, you can't take a look because my screen cuts it off. Well, that's terrible. Tell you what, let me try and adjust that down. So this is my first time using this system, and it looks like it's going to be a good one, but it's also, I think, smarter than I am. So here's the statute, and that lays it out for you. I'm looking at a very small representational window on that monitor. But so notice there are no known errors. This has nothing to do with what it said it does. So we know that that is bunk. Now, it provides for a rule that the law specifically allows. Again, this isn't a rule. It's not listed in the statute cited. Then it says because a minor guardian ad litem would be appointed. Yeah, I don't know why. Then best interest considerations. Okay, this is not there's nothing here that's correct. However, it sounds confident. And that is the absolute biggest threat here, is that it sounds confident. So The drafting language is plausible, express intention to make no provision, specifically intentionally disinherit, acknowledge child is my child, clear specific intent, normal disinheritance clause drafting style. A viewer, a lawyer, pressed in a hurry and not paying attention might actually use this, think, hey, it looks legit, and it's wrong. It's a big problem. Any lawyer watching is going to know that, Missouri has pre-terminated heir issues. You've got intestate succession. Disinheritance is drafting intent clarity issue. And avoiding the pre-terminated child treatment statutes don't neatly say the requirements for a valid disinheritance clause. The motto is doing what they do. It's picking a statute that's in the right neighborhood. It's describing it confidently. And it's hoping that nobody checks. Okay? Now, it's also inventing legal mechanisms that don't belong in a will clause. Okay? Guardian ad litem. Guardian ad litem might be appointed in a probate matter involving minors, but it's not likely going to happen here. That has more to do with the child receiving money and setting up a conservatorship on behalf of the child if the funds are greater than $10,000. So this isn't getting this done. But let me tell you and let me show you what these things are good at. Okay? Because this is dangerous. If you use generative AI, you're going to lose your license. Or if you're pro se and you're doing it, you're going to have other problems. Significant, real, valid problems that opposing counsel is going to tear you to pieces and laugh while they're doing it. That's what I did before I started doing estate planning. I was a litigator. My job was to come in and break stuff. And you're leaving an ample opportunity for somebody to break stuff. So right now I just popped in a clause. Please review the attached document and extract all the names, contact information, and context why the name was included. What I'm referencing here is I'm about to drop in as soon as I can find my file, I'm about to drop in a text file that I created from a dummy defendant's response and objections to plaintiff's first interrogatories that I found online. And I did that because obviously I'm not going to use any of my client's information or anything from a client's case. So I'm using this dummy document and I dropped it in. Now it's going to do one of two things. It's either going to hallucinate and make all the names up because it can't read the document, or it's going to say, I can't read this document. Can you post it, copy and paste in text? So I'm hoping it's going to ask for it to be copied and pasted in text. And the reason for that is the type of document that I used. So I saved it as a text file from a PDF, and it's saying that it cannot use that. So I have it open. I'm going to copy. I'm going to paste. And this is the entirety of the document. Oh, wow, it's still writing. Holy cow. Okay, I want you to stop because we're not going to wait on that. And just go ahead and paste the entire thing in. And now it is going through it. It's collecting all the names. Breakdown of the names in the text. Jesus Aramilo. Look, I don't speak Spanish. I know I'm mispronouncing them. Please don't hold it against me. But you can read those. These are parties involved. Pulled that out. Legal representation. Maria Dominguez. Florida. I'm assuming that's a fake bar number and fake contacts. Julian Bolivar, roll through all this. So it pulled all the names and the context in which they were in and out, gave a little bit of additional context here, and that's good. It did what we were wanting it to do. Now, if all you did was pop your discovery documents in to get a witness list, that does it. It does it much faster than paying a paralegal. I'd have paid somebody 30 minutes to go through and pull all the names out. But this next clause, please list every question to which an objection is made and include the objection. That's going to save me a ton of time. Well, my paralegal a ton of time, and Erin will be very thankful. But now it's going through and it's going to pull out all the questions. Interrogatory number 1, overbroad, oppressive, unduly burdensome, and calls for speculation. Interrogatory number 2, vague, ambitious, overbroad, oppressive, unduly burdensome, argumentative, calls for speculation. Interrogatory number 3, vague, ambiguous, overbroad, oppressive, unduly burdensome, argumentative, calls for speculation. So That's kind of impressive. So it has all of the interrogatories that had objections, lists them out, laid them out there, very nice. I now have the contacts, or I have all the witnesses. If the contact information is included, I have that in the context in which they are named as witnesses. So I'm going to go ahead and ask it to draft an email to my paralegal, Erin, and ask her to put together a plan for contacting the named witnesses and to notice up the objections for hearing. I got the interrogatories in 20 minutes ago, turned it into a text file, dropped it into this 27B, and in less than 30 minutes of time, I now have this email to send out to Erin. Please start working on a plan for the Aramilo and Jimenez Najrano case. We received the responses and objections. Like you too, witness contact plan. Begin compiling a plan to attempt to contact named individuals. Prepare necessary documents. Formally notice up the objections for hearing. And let me know if you see any immediate challenges. And it's reminding me to put my name in here instead of leaving your name, which is awfully courteous. Okay, so this is what an AI is good for. It's good for saving time internally. It is not good for pumping out information into the wild in generative AI text and textual information. So please, for the love of God and everything holy, do not use generative AI on your legal documents and legal writing you are putting out to the world. I use it internally. We're going to go into the further uses I use it for. Now to run this Gemma 3 27B, by the way, the model is free. Olama is free. You can download it on your computer. Just search Olama. You can download it. It'll run on your computer. Gives you a nice window. Then you can download 27B. But you got to have the horsepower in your computer. Right here, I've got an old computer. I built it 6 years ago. It has a Gigabyte Aorus 570X motherboard. It has a Ryzen 9 series 3900X CPU. It has a RTX 3090 GPU. I just put it in. I crashed my computer for a week, burned out my my power supply. Oh, I was in a terror. I'm not going to get into that. But the when I put that GPU in this week, that GPU, it's like $1,600. The entire computer total, you're probably into it for about $2,300-$2,500 today. Not an overly large expense, but saving 2-3 hours of paralegal time per big document you get in. We do the same thing with request for production. So probably about 3 hours of paralegal time just pulling together the objections and getting the witness's name. Yeah, that's worth it. So what is that? That's equivalent $60 an hour plus the taxes I have to pay. Call it $75 an hour. And assorted benefits. So yeah, we're probably closer to 90 an hour for the paralegal, $2,500 for the computer. If I can save, what is it, 30 hours? 30 hours over the course of a year, the computer's paid for itself. I'll save 30 hours in a month. Okay, 10 cases I can do that with, I'm gold. It is worth it to use these models in a law firm as long as you use them correctly. We'll talk more on that in the next one. Thank you very much. Please hit like, subscribe, and I'll see you again.